The highest bodies of SAFA are the Congress, which is the supreme and legislative body of SAFA, the SAFA Council, which is the executive body of SAFA, and the Management Board, which deals with all matters requiring immediate settlement between the meetings of SAFA Council. That may be seen on Annexure 3, Your Worship. Article 47 of the SAFA statute, I pause here to mention that those are not the only bodies, but the highest bodies of SAFA. There's quite a number of bodies which are not really relevant for this hearing, Your Worship. Now, according to Article 47 of the SAFA statutes, it also refers to another body of SAFA, which is the Legal and Constitutional Affairs Committee. This body is generally responsible for all legal issues within SAFA. That appears on Annexure 4, which is also attached, Your Worship. I submit that none of the above-mentioned bodies, and including all other lesser SAFA bodies that I have not specifically mentioned, make provisions for laying of criminal charges against SAFA Council members or office bearers of SAFA on behalf of SAFA, where there are criminal offences committed against SAFA. I submit that in the absence of such express provisions in the SAFA statutes, any member of the SAFA Council, that is any NEC member, as well as any accounting officer, that is the CEO and CFO, is entitled and obliged to lay criminal charges on behalf of SAFA against anybody who commits criminal offences against SAFA. Such member or official shall not be acting for his or her own personal interest, but on behalf of and in the interests of SAFA. SAFA is a public benefit organization whose aims and objectives are to carry on public benefit activity regarding the administration, development, and promotion of the game of football in the country. It is therefore in the interest of the South African public that this organization be protected against criminal activities both within and outside of the association. Where the President and other office bearers, particularly the accounting officers of SAFA, are the perpetrators, it becomes more necessary for the members of the Council or NEC to act in the defense and protection of the association against such perpetrators.
Your Ladyship will see from the list of witnesses, my name is not there. So again, he's blindsided me by saying, oh, you're going to be called as a witness. Mr. Sadebi's name is not on the list of witnesses. So with respect, my lady, he's making all these things up. The issue, according to my learned friend, that he wants me to be called to give evidence on, is not an evidentiary issue. Article 39.2 or .1, whatever it is, my lady, relating to signatures on documents and contracts, it's a matter of legal interpretation. In fact, I would have volunteered to give evidence in this case if I was going to stand there, give evidence, and your Ladyship would accept my evidence to say, oh well, Dr. Jordaan was perfectly entitled to sign the contracts. Believe me. Your Ladyship would have failed in your duty. Your duty, my lady, is to make that decision based on the interpretation of the agreement. It is not for lawyers to come and stand in a witness box and give legal advice or give an opinion. So there is nothing that relates to the charges, and the charges relate to this GRIT contract, that's the PR people, and the Beaver contract, which is the security people. Quite rightly for a change, my learned friend has not implicated me in any of those contracts. I don't know anything about it. I've never been involved in it, whether it's on behalf of Dr. Jordaan or on behalf of SAFA. So why he would now want to indicate that he's going to call me as witness, I'm afraid I can't help him.
What the defense is praying for, indirectly, is the staying of prosecution, of which this court has no authority on it, as it's stated in the Taylor case. The court is stating again, the accused persons are not the only person entitled to a fair trial. Yes, I'm saying that everyone appearing before court, that includes the witnesses who have not appeared as the matter stated, they're entitled to a fair trial. meaning that the matter should be ventilated. So basically, I'm saying that the witnesses, even though not so muchly covered by the Constitution, but they're also entitled to a fair trial. In essence, accused 1 and 3 applying for the declaration that they should not be prosecuted. If I hear, they are seeking a remedy which would avert their trial, rather than one which asserted their right to a fair trial. So the court has also cited the case of Taylor. The state indicated that the last part of the disclosure is available and can be obtained by the defense. The factors listed in section 342 capital A2 are not present. I must say that I've investigated the matter the whole day. Starting with the first leg, have you established the delay, Worship? I have not identified the delay, taking into account that the matter just started in November. So there is no delay. And this court also has no jurisdiction to stay the prosecution. On that basis, I'm saying that Section 342 capital A, it is premature in these proceedings. And this court is dismissing the application.